Well, hi, welcome back to Legal Risk Management. I'm here with Matt Whaley again from Ernst & Young. Matt, thanks for joining us back here for another session.
Pleasure, Chris. Wouldn't miss it.
Yeah. So today we're going to be dealing a little bit with legislative and compliance risk out of Chapter 4 of our book. And Matt, tell us what we're talking about here. When we talk about legislation and compliance risk, what should people be thinking about?
So I think what we're thinking about really are those big extraterritorial laws that if you fail to understand the impact of them on your business and to comply with them effectively first and efficiently second, they can result in huge regulatory attention, reputational impact, fines, all associated losses of that nature. So we're talking really about the big laws that affect lots of businesses around the world. You can, of course, you go to a more specific level depending on the type of business that you're working in, and there may be specific laws, regulations that affect you, but it's easier, I think, just to say, well, what's a big extraterritorial law and how does that apply to a business or a sector, and how does that get interpreted through?
So this is something that I think has become increasingly important over time for legal risk management to deal with these voluminous laws. It's got to be kind of hard, isn't it, for a corporation, particularly one that's a multinational dealing across jurisdictions, to pay attention, try to take into account all the different jurisdictions' laws, because some of them probably contradict with each other too. I mean, you're working in France or you're working in Russia, they're going to have different ways of doing things, right?
Yeah, very different if you're looking at those two jurisdictions. A rule of law, perhaps less so. But yeah, there's definitely more seriously, there is a layering of laws across jurisdictions. So and working out which is going to be prevalent. So normally you would work that out as to where are you domiciled, what's your headquarters, and you adopt a policy of complying with usually the strictest set of laws that affect your multinational. And then within a particular jurisdiction, you've got tiering, like a wedding cake of interpretation of law. So we were talking about just before, so if your parliament sets a law at a high level, for example, and then your regulators, so your SEC or your Fed, get hold of it, they start to interpret it for a sector, and then at another level down, bureaucrats start reinterpreting that and putting additional set of regulations. Then you get a tiering effect within jurisdictions, and the requirement of some regulators like the Fed to map every single regulatory obligation that you're subject to, which can be 35, 40, 50, 60,000 regulatory obligations that you have to meet around the world. Just doing that as an exercise is incredible to think of, but actually then keeping it up to date once you've mapped all those obligations, given the amount of change that happens across the regulations, legislations worldwide, it's huge.
How many scribes am I going to have to employ to put this all together? I mean, you're saying 35, 50,000 of these different regulations in a year that I've got to try to do. I'm going to have a lot of Smurfs working for me, right?
Yeah, well, I suppose you don't need to do that every year, right? You don't get another 35,000 every year. Once you get 35,000, you've got a baseline, and then you're just looking at the delta every year. But yeah, there's going to be a significant amount of change. It's a significant activity. And the key to it is to take a risk-based approach, in all honesty, and not worry about all 35,000 obligations you might be subject to, but worry about the 3,000 or the 300 that could take you down if you get them wrong.
Is this something artificial intelligence or technology can help with, or do you really need people parsing these laws to start with to sort of build that institutional know-how of how to deal with it and build a culture around that?
For the actual, for the day-to-day work of reading the regulation and taking out what is an obligation, yeah, absolutely, you should use technology to do that, because it's often as simple as going through a document and finding "you shall," or the institution will, certain affirmative statements. that Tobias has been through. Tobias Mahler, Professor of Law in Oslo, University of Oslo, has been through and worked out how to do that in contracts and separate out obligations. We do it here as part of our consultancy exercise for particular pieces of legislation. Just pick out everything that looks like an obligation, so you can map that and list those out. But you can point technology at that. Train it up appropriately. It won't then tell you what you should be complying with and give you the risk analysis, but at least it gets you to a full list of obligations you should be thinking about.
And how would I know, let's say I get a whole list of you shalls, you shall nots, and it's parsed out for us. How do I know how much priority or weight to give to tackling and changing our culture and our corporation if we're not doing good compliance with certain things? I say, okay, there's 10 you shalls that we're not even looking at or considering right now. Do I need to jump on those right away, or how do I assess the threat of those different you shalls or you shall nots?
So that's where you need to get your legal risk impact charts out, understand the volume of business that is affected, the value of that business to you as an organization, the level of risk in terms of those obligations, whether you are actually complying with them without knowing it. In my experience, it's really unusual for a business not to know what their regulatory obligations are at the most micro level. So you keep going down an organization and you find product managers or you find salespeople. They're normally pretty aware of what law and regulation applies to them, particularly in regulated sectors, which is what we talk about now, right? So financial services, telecoms, oil and gas, or any regulated sector, you're going to be aware of the regulations that you're subject to. So it'd be unusual to be completely non-compliant. So that's why the risk-based approach is really important, to work out which are the ones that you should be investing the most effort in from a cultural perspective, and from a control perspective, to minimize the impact, minimize the likelihood of you having a breach somewhere.
So you're saying somebody in the corporation, probably the person who's most relevant, who's doing the day-to-day operations that would be affected by that regulation, probably knows what they're doing. But then why do we need to even get involved in sort of top-down legal risk management at all? If everybody's doing their job and sort of following this stuff, talk through that hierarchy and that sort of internal firm correspondence and discussion of these things so that we understand better what are we tweaking or changing or adapting to in that top-down assessment nerve center analysis of what's going on.
Yeah, so from the perspective of mapping every single regulatory obligation that you're subject to, and I know it's a Fed requirement, but I'm not entirely sure why you have to do that other than to notify the regulator and make them very aware that you know what you're doing. There is an evidence to there is a requirement now to evidence that you know what you're doing. So I guess that's as good a reason as any if some senior manager is going to be on the hook if they don't have a full set of obligation maps, then that's a reason. I'm in two minds about, in all honesty, I'm in two minds about the exercise, because I think it's a useful bit of information to have, incredibly costly and time consuming to put together and then to maintain it. And most people approach that exercise on the assumption that an organization doesn't know what it's doing, which is, right. I've never found that. I've never found an organization not to have a clue. Certainly not in a regulated environment, because you wouldn't get your license. So I think that, but that actually gives you a clue as to how to carry out the exercise. If you start from a bottom up, and what obligations do you have to meet from the most detailed level, you can start to build that up from the people that already work for you, rather than going top down and doing a regulatory analysis.
So that's interesting. We're going to basically call in different groups of people, and we talk about in our sort of a target operating model where we have different units within the organization talking to each other. Would this be sort of, okay, we're going to call in the engineering department and sort of get an assessment of what do they see as the relevant issues that they're having to comply with on a day-to-day basis, and then incorporate that into our map? Is that?
Yeah. So what are the key, for them, what would be the key local law regulation that you have to comply with that takes energy and effort? So you get a view of what they see as being most important, and then you would layer over that your global view or your country level view of what are the most important laws and regulations that we see as a significant or systemic risk. So the Bribery Act, FATCA, foreign corrupt practices, yeah, it's all financial services again, but
Yeah.
those big regulations or multinational laws that actually everybody needs you to get right. And how are you layering that across the local, checkbox regulatory compliance, and putting the sort of spirit of the law, regulatory compliance on top of that?
Yeah, that makes good sense. Let's get to the hard question then, which is it's sort of the chicken and the egg. Which came first, legal or compliance? Who's in charge of this ship, and how should this be sorted out? Because that's something we struggle with, I think, on a day-to-day basis. People are always struggling with that question, and we try to tackle a little bit in our book. You recommend ultimately placing the locus of power and responsibility with the general counsel. How do we go to that decision, and how should we try to sort out these various roles about who's coordinating what information or executing and so forth?
We recommend.
Yes,
We did.
I put it on you because if it goes wrong, I'm managing my risk.
So we do recommend that. Yeah, we do recommend that because one of them needs to be in charge. So the main recommendation is that you have a single person in charge of both departments, and that they work very closely together. Too often, if you have a head of legal, head of compliance operating, both reporting to the board, those two departments work independently. There's a lot of either duplication of effort, which is fine, it's a bit costly, but it's better to have two people doing something than nobody, or you end up with a huge gap that nobody works in because each thinks the other is going to do that. So it normally makes sense for a general counsel to have legal, obviously to have legal, but to have compliance within legal, because you have compliance we have it within the legal risk taxonomy, for example, as a subset of legal risk, legislative, regulatory, adequate compliance with law and regulation. In fact, it's just a subset of legislative regulatory risk. You still have the awareness and assessment that you need to do, which is often where you would want lawyers to be interpreting the law or regulation and to be pushing back to legislators and regulators where they think the law or regulation isn't going to achieve its aim. And you don't get that from typical compliance departments, where they are designed and built to comply with law and regulation, not to question. So by combining them, first and foremost, you end up with two skill sets that complement each other very well, and you get those two skill sets to be working together much better as a single department. Whether that reports to the general counsel or to the head of compliance, who might be a lawyer, and it's really just badging at that top level. There's a trend, I think, to split them actually in financial services, which is a bit of a worry.
To separate the departments entirely, or
because a lot of the activity is quite separate. So a compliance department would be much bigger, and because everybody talks about compliance risk, so that small subset of legal risk, which results in the huge fines that we've talked through already, they're kind of compliance fines. But they have a legal root cause. So a breach of law or regulation is a root cause. So, but because the output is so big and the risk exposure seems to be much bigger from a compliance perspective, that gets all of the investment, that gets all the attention, and legal have kind of, I can feel that they are being pushed out or downgraded at the expense of compliance, because compliance are getting all the investment and all the attention at board level.
So let's talk about that. We're sort of condoning or advocating for integration when the trend is towards segregation or separation here. How do we create those synergies again, if that's really ideal, to have these two departments working dovetailed with each other when their entire modes of thinking, as you just pointed out, are somewhat different from each other? One is sort of saying, yes, how do we do this the way they want us to? The other is saying, how do we sort of anticipate this and fight this if it's a problem? Those, to me, are two very different modes of thinking. How could we successfully integrate those two?
Yeah, we are certainly booking a trend with this.
Maybe that's a good thing.
Yeah. So, but also, we're on the forefront of legal risk and legal risk management techniques and practice. So, we should be booking that trend a little bit, I
Yeah,
think.
yeah,
So, if we accept that legal risk is an issue, which we do, if we accept that it results from multiple interactions of law and regulation with business, as we do, so leg reg is one of them. You've got contracts, dispute, intellectual property, and non-contractual obligations, so conduct ethics related issues. And you accept that a lawyer needs to be involved in the assessment, identification, assessment of exposure to those risks, but that a lawyer isn't necessarily the best person to manage ongoing control of that risk, absolutely advising on exposure and on individual matters and on crises that come up when an obligation is breached or a right isn't adhered to, and you want to go after a third party. But the day-to-day management of how the firm complies, of the operational processes the firm has put in place to comply, the monitoring of controls, the integration with risk frameworks, that isn't in the natural skill set of an in-house lawyer, certainly not, and not of private practice. So, I mean, I'm not a lawyer, and yet I'm running a legal risk practice, and the reason for that is that I can integrate concepts of law with concepts of operational risk and bring the two together really nicely.
yeah.
He said modestly.
Yeah.
But it's an important point in that, if we accept that legal risk is a thing, and then it's an important thing, and that lawyers have a role, but that they can only do so much. I need to put my hands up. They can only do so much. Then you need somebody to pick up the other side of that, the operationalization of that. And some of that is compliance, not all of it, because compliance have a specific role to play in terms of monitoring of staff behaviour to ensure that individuals are complying with regulatory obligations. But even they, then when you get to the operationalisation, aren't going to be take responsibility for control testing. And they're not going to take responsibility for operational risk integration and for all of those things that they struggle with themselves as a department. So you need to have legal and compliance working together, because compliance give legal the capacity to test some element of the controls, certainly along that big risk tranche of adequate compliance. And actually they could apply those techniques to contractual risk quite easily, to the other risk categories. You also need to bring in operational risk, because they understand the risk frameworks and the lines of defense and how the regulated environment operates, and they can give guidance to the lawyers and to compliance as to how to integrate what they do into business as usual process, rather than it always being something that, the lawyers look after that, but there's only 100 of them and there's 100,000 people in the organization. So that's why we think they should be integrated. That's why we're booking the trend, because if you're going to manage legal risk, if you're going to genuinely have oversight over how legal risk is managed throughout the entire business, and not just on a transactional, we've dealt with 10 crises in the last month and given advice on 8 transactions, at the level of we've signed 100,000 contracts and the risk exposure across those contracts is 83 million. And we've got 11 disputes running, and we know that our strategy is going to save us, is likely to save us 25% off the expected settlement. So we're doing well on those. You need people you need to start doing that to evidence oversight. And that is a combination of skill sets that needs to be brought together.
Yeah, it makes really good sense. Is this going to be where a nerve center is effectively created? You have people sort of on the same floor, all in communication with each other. Who's calling the switching? GC can't be everywhere all at the same time. And a lot of these decisions day to day in terms of we're going to prioritize and put resources towards this new reg here, and we're going to comply in the following way with this. We're going to get somebody from operations to tell us how to execute it. Do we build teams around a given piece of regulation that's being brought up, and who's going to call for that prioritization of this one? We're going to look at law A and not law B right now.
Yes. So organizations do build teams around specific pieces of legislation, regulation, and they will typically be a program or change management team who call in subject matter expertise from legal, from compliance, from IT, from human resources, from whichever business unit is going to be affected, dependent on what the particular law or regulation is. So they will pick it up as a project when a new, this is really new law, when a new piece of regulation or a change in regulation comes that's significant. So the fact is, for example, the UK Bribery Act, when that came out, GDPR is a current poster boy of regulatory compliance. So you have those teams set up for change, getting it as a business as usual operation. So who manages that moving forward is where things can quite often start to slip back between the cracks, because those siloed teams come together only through a change program.
Yes.
And through the coercion and the bullying and the cajoling of those program managers and change managers, bringing them together. What we need is to have second line legal risk teams, for me, reporting into the general counsel, or they could equally report into the COO or the operational risk officer or the chief risk officer, monitoring legal risk exposure, testing, reporting on how effective controls are, picking out risk indicators and performance indicators, to help senior management in firms to actually understand what their risk exposure is and how it's being managed and where they should invest to manage it better moving forward.
So, and also just what you said prompts to mind that once there's sort of a change team that's brought together, has instituted whatever needs to be changed in the corporation to deal with a certain new piece of legislation, it's almost that there has to become an institutionalized memory of that process of what was decided and how it was done, so that, 5 years henceforth, if all of a sudden a regulator shows up and says you're not doing this right, somebody's got to have some memory of how this was all handled, right? And how do you institutionalize that memory so that it's there in the case of an actual crisis that comes up?
So that's the absolute key to getting it into business as usual. So it's not so much a memory of how it happened, but it's taking that change process and putting it into business as usual operations. And organizations are built on a series of processes, a whole raft of documentation, relationships, interactions. And the governance program that you put across the organization, so which we talked about chapter 3.
Yeah.
The policy, the standards, the procedures to implement policy, integration into risk management frameworks that then links into risk controls across multiple risk areas will all be managed through a similar sort of framework. And then the people that you employ to test those controls, the reports that go back through to governance to prove that to the policy owners how the risk is actually being managed in the front line, so that tone from the top is reflected in an echo from the bottom. Joining that through in the middle. That's the essential piece to evidence compliance should the regulators come along. And one of the reasons GDPR is so the General Data Protection Regulation, it's EU law that was agreed last year and is coming out May next year. It's going to be in effect coming to effect from May next year. One of the reasons that's such a big issue now is not just that it's huge increase in fine levels from £500,000 to up to 4% of global turnover.
Wow.
Absolutely huge, but because there's a requirement in there to evidence compliance, to show how you comply with the regulation. And it's a new thing. It's a great thing, really, because that's the way to effect change in organizations. And it's causing a huge tranche of work across all sectors, all countries that process EU residence data. So it's massive impact on worldwide business, because there's a requirement now to evidence control with this new form of legal risk, privacy risk.
Mm-hmm. Mm-hmm. Yeah. I'm going to switch gears for a minute, unless you've got more to say on this. Are we good on this part?
No, we're good. Sorry.
Okay.
Yeah.
So I wanted to back up for a second and talk about analyzing the risks in the first place under the legal department. We talk in the book about horizon scanning, looking towards How do we assess and identify risks in the first place? How should we have ears to the ground, and how does that work in a major corporation working across so many jurisdictions to really scan effectively to make sure that it's picking up on any potential nuanced changes, modifications, or even down at the bureaucrat level, something that is going to start to grow into a problem rapidly enough that change teams can be brought together to deal with it and get out in front of the problem.
All right. So the key to that again is to take a risk-based approach to understand, what areas of legislation or regulation are a priority to your business, and focus on those, and not to boil the ocean and try and identify every small piece of law or regulation in every jurisdiction that, even if it did have an impact, it might be 10,000 euros, or it might be £100,000 or $50,000, and it's not going to really affect the business, and may not be repeated. It could be a particular circumstance, very nuanced, specific circumstance. It's to understand what are the strategic legislative regulatory risks that your business faces. How are they being managed all the way through all levels of the business? Because if you end up with a systemic non-compliance to the Bribery Act or to foreign corrupt practices, you end up in a serious place. If you have a small piece of regulation in Malaysia that you fall foul of, or get involved in a dispute, that's generally going to be quite contained to that jurisdiction. It's not going to have much contamination, even at a regional level. So if you can establish the law and regulation that has a significant effect of contamination, should it go wrong in any jurisdiction, focus on that, and then again rely on your local offices to understand what's happening locally. You can track, if you're a significant organization, you're going to have a lot of law firms at your disposal. You can ask them to carry out horizon scanning for you, and I'm sure they will do that already, and there's huge swathes of information out there. There are legal information services that track law and regulation all the way through its life cycle, and will give sectoral views on which laws are particularly significant for which industries. And it takes a long time to get a law passed through, right? So you get it's unusual that it's like a bing. Oh, how did this happen? Where did this Bribery Act come from? I've not heard of it before. It doesn't really happen. Yeah. So you normally get some warning. It's just balancing that against the organizational budget cycle and trying to get it budgeted in early enough that you can get a view of its impact, but hold off on action until you know exactly what that impact is and what the most cost-effective way is to comply. Because it's easy to spend a lot of money complying with something that sounds really scary, and then realizing that you went early and you could have done it for much more efficiently and spent much less money.
And we talk in the book a little bit about the potential role of lobbying in that regard, that actually interfacing with the government and getting some sense of the regulator's intents through that lobbying process might be a way to get ahead of that problem, to sort of get in the minds of the regulators and figure out the rollout process for the law and what the intents are behind the enforcement of it.
Yeah, and it's really important to understand that intent. And it speaks to the non-contractual obligations risks as well, in terms of understanding what the spirit of the law or what the spirit of the regulation, what it's trying to achieve, and complying with that over and above the letter, because the letter is open to interpretation and nuance, and people can think that they're complying, are more prone possibly to rely on complying with the letter, even though they know it's not quite the spirit of the law. And that's where you generally get that's where things, where you get the regulators involved. So I've completely forgotten your question.
No, you got it. I think that was that was completely sufficient. The third step in this process is sort of looking at the question of proportionate compliance or prioritization that we talk about in there. And we talk about sort of three things in the compliance matrix that we have in the book. Number one, that there's an impact on resources that we have to weigh out. And two, that we're going to have to assess training and competencies. We've already talked a little bit about that. and 3, getting our systems and processes right, which we've also talked about. How about the impact on resources, though, which we sort of glossed over? How do we figure out which beans to count and put in which pot? And if we have a limited budget of people, of staff, of tech, and so forth, and we've got multiple large pieces of legislation, all of which are icebergs around us, then how do we,
how do you prioritize?
Figure out where to allocate? Yeah.
Yeah. So I mean, there is a finite resource pool for every organisation, and that needs to be balanced against the need to comply with law and regulation that affects your business. That's the prioritisation matrix is about understanding the cost, not just in terms of the cost in terms of, can you do this using your existing team? So is it a question of updating processes, rolling out some training, building on systems or using systems that already exist? So there's a minimal business as usual impact, or is it such a significant impact that you need to appoint a head of foreign practices or a data protection officer that you didn't have to have before? So you need to appoint new people into the organization, which is a significant business as usual cost. Or do you need to invest in upgrading or implementing new systems, so to comply with some of the financial services regulation, MiFID II, for example, or SOX out of the US? Significant cost and impact because of the investment in IT infrastructure systems in order to facilitate compliance. So there are levels of cost and impact in terms of the cost to comply, as well as the potential outcome should you fail to comply and have to go to the regulator.
See, to my way of thinking, though, as more and more laws come on the books, and Philip Wood in our book, we reference him, Queen's Counsel, talking about this, that it would take over 100 years for the diligent reader to get through all of the the U.S. financial laws that are out there. And we also reference that there's been sort of a 1,000-fold increase in the amount of law on the books in the last 200 years, and that it's projected to double again, I think, in the next 15 to 20. So with this sort of growing amount of compliance, isn't this ultimately, in terms of as you point out, every firm has finite resources to deal with? Aren't there going to be sort of stiflings of innovation, of money being taken away from other sectors of the corporation to deal with these staggering loads of compliance, of regulatory scanning, and so forth that are coming down the way?
Yeah. It's so it has a huge impact on the competitiveness of certain markets. So a heavily regulated market has a huge cost to entry because of the regulatory burden and the compliance burden. So the regulator in the UK, the FCA, has created a sandbox for new banks, new financial services firms to experiment delivery of services in a live environment without being fully regulated, because the regulator doesn't want to become a barrier to competition in the market.
Yeah.
You've also got new sectors starting up, so RegTech, technology solutions to try and keep track and monitor these regulatory obligations. You've got law tech starting up, so contract analytics, negotiation tools, contract management tools to try and help with a greater volume of law and legal services. So there are, I mean, it is huge. It is growing, and it's leading to new markets, but also it means that you have to take a far more intelligent approach to what you're complying with, why, to opening up relationships with regulators. The other flip side of it, from the regulatory side, of course, is that they now have more to do, and they don't have necessarily enough people to do their side of it either. So I don't think the constant doubling helps anybody, and I'm sure at some point there'll be a balance, and there'll be a.
It seems there would have to be something, because ultimately, if I'm a big blue chip firm who's on the NASDAQ or on the S&P or something like that, in some ways there becomes a strong disincentive if the laws get too unwieldy to being large, because it ends up just being too costly. I'd rather play in the sandbox with the smaller players, perhaps, or downsize or pare down my firm simply to try to avoid the cost of regulation. You know, if there's certain market cap, and above this market cap you're expected to comply, maybe I drop below the market cap and my costs of compliance go way down.
Yeah, yeah. Although your ability to make profit are also down, just because you're limited by your size.
Yeah.
So there's a balance there, and there's also a balance between, there is an increasingly burdensome amount of regulation, but that regulation is there to protect markets and to protect consumers, and therefore, although it's easy to see it as a bad thing if you're looking at it from the perspective of the regulated market, it's normally a good thing from the perspective of that market's customers.
Sure. Yeah.
So, there's a balance there to keep, and that's important to keep in mind, even if you're working for the regulated entities, because that's the way that you avoid falling foul of spirit of regulation, by understanding what it's for and working within that spirit, having an open dialogue, regular conversation with regulators, doing the right thing by customers, doing all the things that we talk about in the book, and still making money because you're providing a valuable service that people want to buy.
I guess what comes to mind is the adage that I've heard before, which is there's no opinion that hasn't made its way into a law in some form or fashion. And that's the question, is there any incentive to stop producing so many laws that ultimately may skew that balance in one direction or the other? And, if we looked at history so far, the answer has been no, at least over the last 200 years or so. But maybe as we start to become more proficient in this, technology flourishes and sort of proliferates, we will, as you're mentioning, strike some sort of harmony between protection for consumers and allowing firms to innovate without stifling them.
Yeah. Watch this space on that one, I think.
Yeah. I think that's about all I got for the day. I think this was great, and we really appreciate your time in this and your wisdom, and look forward to chatting with you some other time.
No problem. Thanks, Chris.
All right. Thanks, Matt.